Hey, right, everyone. Um, Will is running late today, so he's going to join us shortly. So it's just me and Shannon for now. Um, got a few questions coming on the live chat already. Just a few, the usual sort of stuff. So please don't put personal information in the chat. Just ask the question hypothetically about a hypothetical situation, and you'll get the same answer. What else you need to know? If you haven't already subscribed to the channel, you probably have if you're here, to be honest. But if you haven't, then yeah, please do. And if we've got any of the regulars here tonight, do say hello on the chat. Um, yeah, just be nice to see who's in. Little bit, I thought I'd just do some very quick news bits before we get going properly. One is that we've had a lot of questions around B&B's suitability TA and stuff over the last however many months. There was an LGO decision this week from Nottingham, and basically the family was kept in B&B for more than 6 weeks, well, 9 weeks, I'm guessing, and they got £200 per week that they were left in TA. It's taken 18 months to get the decision, mind you, so it happened in March 2022, and they've just got compensation now. But it just kind of goes to show how the LGO calculates stuff. So if you're in B&B more than 6 weeks, then yeah, worth complaining as soon as possible, really. So there's that, and there's a bit of also a bit of news which I think is really cool. So a former colleague John Allen over at Just Us in Bedford, he had been raising Travelodge's policy. So Travelodge generally will take people with pets, but the Travelodge in Bedford was basically within their contracts. I think I'm not quite sure the details. They were like not allowing homeless people to have pets in the hotels. So John complained about it to the chief executive of Travelodge. He got the MP involved, did his usual thing, just kind of bull in a china shop, and the travel lodges just basically changed their policy so that homeless people now can have pets in there. Obviously, it doesn't fix every problem out there, but it does go to show even private companies that you don't have any power over at all in terms of we can't hold them to account. Actually, they do. They can be reasonable and they can respond to complaints really well. So yeah, that's that. A few other bits. So we've got some questions coming in. Hey, right, Youssef, nice to see you. So yeah, we've got two people asking questions, and there's one of the bits overlaps. So I suggest we kind of start with that. We've got about 5 or 6 questions that have come in through the week, so we'll get onto that as well shortly. But basically, the first question is essentially I'm guessing someone's in temporary accommodation, but it doesn't really matter. Someone's under the relief duty. The relief duty expired like 3 weeks ago, 4 weeks ago, roughly. Yeah, 3 weeks ago. And there's been no contact from the housing officer. So we've common issue. The default position is just to complain to the chief exec. If the council's duties expired, then you just need to chase them and get them to respond. In terms of the relief duty, so that one thing I didn't realise until the last few months is that the relief duty doesn't actually it doesn't necessarily start the same day the homeless application is made. It only starts when the council is satisfied that you are homeless and you are eligible for assistance, which could be a few days afterwards. So that's how you calculate the date. They've got 56 days from then. The homelessness code of guidance says that decision should be issued on day 57 unless they're particularly complicated, in which case they get another 3 weeks. But most people's situations aren't that complicated. So that's the first thing. It might seem like overkill, but it's the only thing that we know is tried and tested and actually works. So send a complaint to the chief exec. You can Google the chief exec's name on the council's website or whatever. So that's the first thing. Second question is both kind of then talk about intentional homelessness, and so both questions kind of situations where the individual has been told that they're intentionally homeless. Now, I think one of the questioners is saying that the council's only saying they will find them intentionally homeless. That's kind of the fancy term for that certainly I'm familiar with is a minded to letter. So if a council is going to reach a negative decision, then it has to write to the applicant and give them an opportunity to provide more info and kind of defend their case before they make that Section 184 decision. So in that letter, it should set out already why the council think you're intentionally homeless, and you can look at it to see if you actually agree with it or not. And then if you don't provide any information or you don't kind of get them to change your mind, then they'll issue the decision after that. Now, the second kind of questions is basically where I think both questions involve rent arrears potentially. No, I'm just reading into that. So one of the questions involves rent arrears. First thing to say about rent arrears is that it doesn't mean you're intentionally homeless just because you have rent arrears. The question is, was the accommodation affordable? Was it reasonable to continue to occupy it for other situations in other ways? So that could be because it was, in complete state of disrepair. It would need to be really serious, or it could be having a big impact on your health. It could be your risk of abuse or something. All of those things would be relevant to the question of whether it was reasonable to continue to occupy. And if it wasn't, it doesn't matter. It doesn't matter if you went on holiday to the Bahamas or something. That's not relevant at that point. The question is, was it reasonable to continue to occupy in the first place? So loads of people get told they're intentionally homeless. Loads of housing officers jump to the conclusion that you are intentionally homeless if there are rent arrears. It's not necessarily the case. Going back to John from Just Us as well, just made me think of a case he was involved in with Stonewater, where Stonewater's a big housing association. It covers probably a lot of people will be familiar with it. It covers all over the south, if nothing else, southwest over to east. And basically, their policy meant that if you had any rent arrears at all, they wouldn't accept you onto their list. And so John was working with someone who was domestic abuse victim who'd been financially abused, and that was the reason why she was in rent arrears. And Stonewater's policy meant that she was basically barred from being on their list. So John complained again to the chief exec, blah blah blah. Got the MP involved, got the mayor involved, and Stonewater changed their policy just on the first email. So again, just kind of goes to show that highlights kind of actually just because you might have rent arrears doesn't necessarily mean anything when it comes to your future housing. Shannon, feel free to chip in if I'm missing anything or I'm saying anything too quick.
No, I think you are. I think the second case, the second question there around intentionally homelessness is obviously a bit different because they've got children, and they are currently pregnant. And in that case, even if you were intentionally homeless, which Mike's already explained is potentially not possible, or unlikely, but even if that is the case, then you would still get housed, but it would just be under social services. And 9 times out of 10, social services will then just refer you back to housing to get you housed, but the duty would come under social services rather than housing. So they shouldn't be left to rough sleep or to continue their homelessness. They should be helped. Yeah.
Yeah, cool. So I think the code of guidance says that if the council is going to make an intentional homes decision, they should basically. I think it does say with the applicant's consent, but they should refer them to children's services automatically.
Mm.
So yeah, and so in one sense, just with the question. So the question here is, so someone's been told that they've made themselves intentionally homeless. They're in temporary accommodation already for 8 months. They've got three kids pregnant, and someone has epilepsy. So in one sense, the epilepsy doesn't directly change anything, but it might do because it might well be a disability. It might mean that the council need to be particularly aware of it and particularly kind of careful in ensuring that the social services, if nothing else, gets involved properly. So yeah, has that covered it? I mean, we've done quite a lot of other videos. There's some videos on the channel as well about it, intentional
So
homelessness. Oh,
so
go
they've
on,
just
yeah.
added a comment there that's I'm not actually sure of the answer, Mike, but would they be able to stay in their current TA, is what I'm assuming that where they've been placed, or would the transfer over to social services mean that their TA placement would change, or would social services basically just pick up the bill?
We'll say it probably change. It'll probably be most housing providers or most housing options teams or housing homelessness teams, whatever council housing teams, will have like agreements with specific providers, landlords, B&Bs or whatever. And so if their duty's ending, that will probably result in the person having to leave the B&B or the family having to leave the B&B or whatever temporary accommodation it is. But it's not guaranteed. So I mean, there's been cases as well where someone's been in a B&B, the council's duty end under housing law, and the family are able to continue living there because they get housing benefit or the equivalent towards the rent. So it's not guaranteed, but I'll say it's highly likely you will get moved. With social services, they have to step in. They're obviously not geared up to find housing. Often, lots of social services will be like, "Well, we don't do housing, so we can't help. But you just need to I mean, sadly, you have to kind of camp out in the council's office with all your suitcases often to actually get them to kick in. But as Shannon says, what often they'll do is they'll pick up the phone back to housing and say, "Look, we don't do houses, you do. We'll pay the costs or whatever, but can you provide them with housing?" So yeah, it's
Could be
not.
a sorry.
yeah, I was just so it's yeah, to say it's not guaranteed, but it's likely that they'll have to move.
It could
Um,
be quite a good case to get your local councillor, your local MP involved in as well. Like if you're struggling with that, I can imagine a few local councillors be quite sympathetic to that situation. Just getting them on board to try and make that communication, as we saw in the previous question, with them not responding, was to alleviate any sort of stresses and stuff. Because I know again, sometimes stress can be a trigger for epilepsy and whatnot. And again, if it is a disability, then all of this is relevant. Yeah.
so and this leads me to a question I wanted to ask Will. Anyway, we've actually asked it before, and we kind of it's just one of those questions. It's so simple that I've always just assumed is the case. But so the question coming in, they're saying that the landlord was going to sell the property anyway, or was going to was going to evict anyway. So this kind of comes to this idea of no fault evictions. Now, part when the council works out if you are intentionally homeless or not, one of the kind of key things is that you have to link the loss of accommodation to the thing you did, to the deliberate thing you did. So if it wasn't paying the rent or whatever, ASB or something. So in one sense, under that understanding, if the landlord was going to sell anyway, and you can prove that, then actually the reason you lost the accommodation is not the rent arrears, even though you might have had rent arrears when you lost the accommodation, but it was actually it was the landlord's decision to do it anyway. So yeah, when Will gets in, I'm going to ask him that again because yeah, it's just a good one to know. Um, so comment here. So it was affordable. The landlord didn't do any repairs. Wouldn't get the boiler fixed when it broke. So if it was affordable, that kind of eliminates that issue. In terms of not doing repairs and stuff, that's not, that's obviously an issue. That's potentially an environmental health issue eventually. If the landlord's not doing it, they can, they can supposedly make the landlord do the repairs, but that's probably not enough to show that it was unreasonable to continue to occupy. The fact that the boiler is broken down is mentioned there. Again, it kind of depends how long it's broken down for. If it's broken down for a couple of days, it gets fixed or whatever. But if it's months or something, that would be different situation. So I think that covers those two strands. Yeah, there's also just a question about the landlord has served two eviction notices, one with arrears and one without. Now that says to me that I'm not sure what the landlord's playing at there. But there's potentially a way of kind of challenging the eviction itself when it goes to court and saying, well, look, there's an issue with these eviction notices. They're invalid potentially. That might be something that might kick in. So yeah. As I say, I mean, these are kind of common questions in one sense. So it's stuff we've covered before, but those are the kind of the headlines of it. So if we go to the questions that have come in through the week, there's four that come from the same person. They're all kind of different questions, but they will kind of link into each other. So I suggest we start with them, Shannon. So looking at questions 2 to 5 on the list I sent you. So first question: can a person be evicted from his emergency accommodation when the duty ends and there is no place to go? Now, to order to make sense of this, here comes Will. So in order to make sense of this, the other questions show that what I think what's happened here is he's made a homeless application to the council. He's given the council reasons to believe he might be homeless, might be eligible, might be in priority needs. So the interim accommodation duty kicks in. How you right, Will? How's it going?
Yeah, sorry, mate.
That's all right. No worries. So we've just dealt with the questions in the chat. Well, we tried our best anyway, and we're now getting into the questions I sent out earlier. So I'm looking at question 2. So we're doing 2 to 5 first for reasons I'll go into later. There's a residual question we've got from the comments actually, but I'll wait till you've got a bit settled in before I ask you. Well, it's something that's come up before, but yeah, cool. And your audio is probably about to feed back, Will. So if you want to preemptively turn that off, I managed to do it this week.
You mean before I did mute the YouTube audio?
Oh, yeah, that's cool. Yeah, awesome. Yeah, perfect. Yeah, cool. All right. So yeah, we're just looking at this question of can a person be evicted from his emergency accommodation when the duty ends and there is no place to go? So this question relates to someone. It's around priority needs. So I was just explaining. If you give the council reasons to believe you might be homeless, might be eligible, might be in priority needs, the council have to give you interim accommodation. At some point very soon after that, the relief duty will kick in, meaning that the council can reach a final decision on day 57 of that process. But what councils can do is they can start their, what they should do is put you into temporary accommodation or interim accommodation. And they should start their inquiries into whether or not you are in priority need, whether you actually are homeless, whether you are eligible. And if in the course of those inquiries during that relief period, or even technically before the relief period actually kicks in, if they genuinely make good sound inquiries and the council reaches a decision that they are satisfied that you are not in priority need, or that you are not homeless, or that you're not eligible for assistance, then their duty under Section 188 ends. So they don't have a duty to provide interim accommodation anymore. Now, I don't know if it's law, or a lot of places I know they'll give you like 7 days notice, or give you like 3 days notice or something from of issuing that negative Section 184 decision. So there's no easy way of explaining this. It's really stupid how they do it. You can't make a positive Section 184 decision within the 56-day relief period, as in you can't issue a decision accepting the main housing duty, but you can issue a negative one. Hopefully that kind of makes some sense. So even if, so say you're pregnant or something, you're obviously going to be in priority need. The council can't issue a Section 184 saying you're in priority need until the 57th day comes, but they can issue a decision saying that you're not, if that makes sense, if you weren't. In one sense, if you're not in priority need, this is why priority need is so pivotal to actually getting housing assistance under the Housing Act. You can still get advice and assistance and some stuff, but it revolves around priority need often. More so than with homelessness and eligibility. So if you're not in priority need, the council has no duty to house you under the Housing Act, and therefore they can throw you to the dogs, effectively. Not really, but you know what I mean. So they can refer you to the local street outreach teams, who will, pick you up at some point and probably look at supported accommodation options. The council itself, if they're effective and efficient, they should be looking at those other options. So depending on what your locality you're in, often it's not that difficult to get into supported accommodation. Certainly these kind of cowboy, unsupported, unregulated supported accommodation providers, often there's no waiting list at all. You can kind of walk in. But that's really just a last resort, because once you're in there, you're kind of stuck. But yeah, so there is no further duty. Now, if your circumstances change, if your health was to deteriorate or something, you could make a fresh application and you might be in priority need at that point. So that could happen. But there is no housing duty at that point. So I'm hoping that answers that question. But as I say, we've got 3 more which kind of interlink with it. So in fact, this kind of, I think I've already answered this next one. So when the duty ends and no priority need found, council stated will forward details to Rough Sleeping Team. What is this team for someone leaving emergency accommodation? Where to go get help? And what does old age means? So what age is considered to be old age? Now, this old age is what they're talking about here is about priority need. So, one of the factors taken into account in establishing if someone's vulnerable and therefore in priority need is their age. So it could be young age up to the age of 25. It talks about, or it could be older age. But the point is, there's no set age limit for either old age or young age. It just depends on how frail that person is, or often it's going to be other health issues that kick in. So yeah, I'm doing a lot of talking here, guys. So do you want to kind of fill any gaps in I've said there, or kind of restate anything that I've not said very well?
I guess all I would add is that potentially as well, if you're in a situation where they've made a non-priority need decision and you think you would fit priority need, you can challenge that. I think I'm right in saying that they wouldn't house you whilst the challenge is ongoing. But you can challenge that decision if, say, like they've not considered certain information, if they've only, say, seen your GP summary record rather than whole letter from your GP explaining why you think you might be in priority need. So it is also a challengeable decision. So you don't necessarily have to wait for condition to get worse or a condition to arise if you think that they have made that wrong decision. Yeah.
So it's a good point, Shannon. So the council. So okay, so you've got 2 possible options at that. Well, you've got more than 2, but 2 possible options might be. So let's say let's say in this situation. So let's say you're 50 years old. So you're not really old. You're not properly old. And let's say you've got a condition. Let's say PTSD, just for the sake of argument. But let's say in the council's decision, they hadn't made proper inquiries and they completely omitted the fact that you had PTSD. They hadn't looked into it and they issued a non-priority decision anyway. Now you've got two potential options at that point. You can ask for a review of that decision, and the Section 184 negative decision will say who you need to write to, and crucially that you need to do it within 21 days of making the application. And if you provide new information of some kind in that sort of in that situation, the council does have a duty, and there's case laws. Mohammed v. Sadiq, I think, basically says if you provide information which is more than trivial, at that point they should continue to house you whilst the review process happens. But it's like a power rather than a duty. I don't quite know how it works, but what it means is that they'll be housed. But the other option you've actually got at that point is to make a fresh homeless application and say, right, okay, well, you found me non-priority, but you completely admitted the fact I had PTSD, so I'm making a fresh application, and by the way, I've got PTSD. That's new information. They have to start the process again. Now, in the casework that I've done over the years, there are times when, if I don't trust that the review officer is decent, I'll start the application again from scratch, because it buys more time, because the process clock starts ticking again from scratch. It gives more more time to kind of get more supporting evidence, and the hope is that the next application is dealt with by a more reasonable officer. So that's something that you can kind of bear in mind. So you've got this option of asking for a review, and if you provide new information that's more than trivial, then you should continue to be housed whilst the review takes place. Or you could, if you've got that new information that wasn't considered, start the whole thing again.
You could also make a fresh application to a different local authority, couldn't you? Like, say,
Yeah.
if you knew that your local authority was really struggling or was quite poor at making, good decisions and sound decisions, you could almost go to a neighbouring local authority and make the same application, and then they could make a fresh decision, but they would refer you back to, when it gets to that stage, they would refer you back eventually. But there's also potentially
Yeah.
another way around now.
Yeah, so Jan Luber, who's the kind of, I don't know, I'd arguably say he's the kind of most, I don't know, like most senior housing law expert. Is that fair, Will? I don't know of
Yes.
any lawyers which are kind of more prominent in here.
That's very fair.
Yeah. You had some dealings with him recently, yeah. But his textbook, he advises exactly that approach. So if you get a bad decision from one council, go to another council and hope that they are more reasonable. And there's local connection does kick in. It kicks in much earlier than it used to, but it's still not relevant at those initial stages to provide temporary accommodation. And it's entirely possible that you have local connection to nowhere at all, so you can go anywhere you want. Or it might be you've got local connection to multiple places. So there's various ways it could, kind of work out in your favour. And if nothing else, if there's reason to believe you might be in priority need, you should get a roof over your head in the short term. So yeah, so that's that question. Anything to add to that, Will?
Not really. I think you covered everything. I don't think of anything to add.
Yeah. Okay. And so there's a really this question. There's a weird question that comes out of this situation. So if you don't ask, let's say the council they knew you had PTSD, but they made a real botched effort of making inquiries into it. They then issued a Section 184 non-priority decision, which you've got 21 days to review. Ask for review with it's the date you receive it. That can be important, not the date it was written or the date it was dated, which can be a different thing altogether. But if so, I've had it. I remember working with a case. It took me ages to get them. I had to grind them down. But basically, it was about drug misuse, basically. So that they knew she was she was misusing drugs, and but they didn't consider it properly. And it was like 8 months later. So and her situation hadn't really changed. So it was still the same facts. But I basically argued that she had an assessed substance misuse issue which was significant. And was at risk of relapse, which they hadn't actually considered. Now, as I say, eventually they did accept a fresh application. I'm not quite sure whether they actually had to or not, because it wasn't a change of facts, because they were the same facts as before. They just hadn't considered it very well. And in one sense, the decision could have been argued that it was already closed because they hadn't asked for review in that time period. Anyway, that's just maybe a bit too much of a tangent to be useful, but whatever happens, certainly for a professional, you should be challenging pretty much every negative decision, unless it's obviously right. You should be challenging it. It's less kind of viable, I say, for someone who's yeah, somebody who's in the situation themselves and trying to make sense of it all. So question coming up on this kind of local connection. So how can you go to a new local authority to make a new housing claim? Do they send you straight back to the one you came from? So it's a great question. There's two things, right? There's two, again, it all comes down to part 6 and part 7. So we're talking about homelessness here, so it should be being dealt with under part 7, but there are similarities between both part 6 and part 7. So part 6 is like, you know, how to get onto the housing register. Now you can apply to any council in the country under both part 6 and part 7, but very early on you might get knocked back, particularly under part 6, because part 6 is usually quite strict local connection criteria. But let's say you're homeless. Let's say you've got a health condition. I'll keep using PTSD because it's generally going to mean you're in priority need. You could get knocked back by council 1, and where you have a local connection. Let's say you've got a local connection to it. You can then go to any council in the country, anyone you want to. So you go to a neighbouring authority. You don't have local connection there. They know from day one you don't have local connection there, but their duties kick in the moment you give them reason to believe you might be homeless and you ask for help. That triggers the homeless application. You can do that anywhere. It doesn't mention local connection, and the interim duty to accommodate doesn't mention local connection either. So both of those duties are, it doesn't matter. You can do what if you want. You go to any council you want to. What a council generally would then do is ask is once let's say they follow the law, they put you into interim accommodation. They should then ask you the question: do you have a local connection to our area? And if you say no, they can then say, they don't have to, they can ignore local connection altogether, but they can then say, where do you have a local connection to? And if you say, well, area 1, that's where I'm from, they would say, okay, well, you're going to stay in TA here, you're going to stay in temporary accommodation here, but we're going to refer you back to that local authority. And it usually takes a few days, 7 days, something like that, to actually refer you back. And at that point, the first authority might say, yeah, we received the referral, but we've already, assessed this application. There's no new facts. So we're going to stick with the original decision that you're not in priority need. So you can see how it's not a long-term solution some of the time, but there are other situations where, for example, you might be at risk of domestic abuse or something in area 1, and therefore you can't be referred back there. So there's kind of ways in which it might kind of come in. It might be you've got local connection to more than one area. You can have multiple local connections through family or through residence or whatever. So those are all kind of they're possibilities. What tends to happen in the real world is that officers will often get told to screen for local connection immediately, and they'll use that as a they say, oh, you're not from here, you need to go back to your home area, which they're breaking the law. It's illegal to do that, but councils do it all the time, and no one really challenges them, so they get away with it. So that's kind of, we did that event a few weeks ago on the ethics of gatekeeping. That's kind of one of the things that we were talking about there. So yeah, but you can do it, and there are situations where it would put you in a considerably better position, because area 2 might be better. You might have a better experience with the housing officer who actually tries to help you get housed, which may not be statutory housing, but it could be better options. So yeah, hopefully that all makes sense. So next question. Aish, you don't need to wait, mate. Just put the question in. So I'm just getting, sorry guys, I'm just trying to follow the questions here. So guys, can you make sense of that question? So with
which one are you looking at?
Yeah, YN. So basically, someone's received notice to leave brother's home on 6th of November, to leave by 6th of November. Council's been contacted. Application's been accepted on 10th of November. I think that's saying council accept prevention duty. Okay, so right. Okay, so there's a little bit of confusion here. So this person's in priority need. They've got a dependent child. The confusion here is that this idea of a family member giving notice to leave. There's not a real thing, is it? Will you can fill in with this one a bit better than I can.
No, it's not. But has that actually happened here? Because looking at the question, the council have accepted they've accepted a prevention duty, I beg your pardon. So yes, so the idea of a family member, it ties in with the question that somebody's asked earlier up with, and unless you answered it before I got here, about the person whose mother's asked him to leave. But when you're living in a family home, you're not there as a tenant, and it isn't your settled accommodation. So if you're asked to leave, then you should be treated as having to leave immediately. But the council staff have react to this in a number of ways, usually to treat it as some sort of full-blown tenancy. In this case, what they seem to be doing is saying, "Oh, we'll see if we can save you from having to leave." Now, if he was, forgive me, I'm just checking what the background was, because he has to leave his brother's home by 6th November. That's the beginning of the question. Is that right?
Yeah.
So we don't know how long he was
I think
living
what's
there
happened
for.
is that the family's now agreed to extend that license to stay there until the 6th of January. So my guess is that probably the notice said this person needs to leave right away. The council said, oh, they rung them up saying, oh, if we do realize you can be putting them on the streets if you do that. So they say, well, okay, we'll keep them until the 6th of January. Now that's not true. You can't put a parent and kid onto the streets anyway. But I think that's probably what's happened. Is that the council's it's got the family to extend the stay until the 6th, so that they're accepting the prevention duty rather than the relief duty. Now, when January 6th comes along, assuming the circumstances haven't changed and the family still want the person out, then then basically the relief duty kicks in, and the potential, well, in this case, the interim accommodation duty will also kick in. The council will need to provide suitable interim accommodation pending the next stages. So I don't think a lot of the prevention duties, I don't pay much attention to it, but I'm pretty sure they still have to do an assessment of your housing need and the personalised housing plan in the prevention duty stage as well. Am I right? Shannon's nodding. So there's a chapter on it in the Code of Guidance. I haven't read it for a while, but I think whilst the prevention duty is happening, they should still be doing some useful stuff with you in terms of, working out how they're going to try and help you not be homeless when the 6th of January comes along. But often, what the council officers will do is say, go look in the private rented market. Council officer knows full well that there ain't enough private rented accommodation that's affordable for people for that to be a viable option. But they kind of, I get really frustrated because housing officers tend to say that sort of thing and then get annoyed with you when you haven't found anything, and yet they know exactly how difficult it is in that area to actually really, find something. So, so in terms of what can be done, well, the family could go back to the council and say, well, we want these people out now, and the relief duty would kick in at that point. They could just force the issue, or you can wait until the 6th of January comes along and be prepared for the usual nonsense of kind of having to chase the council up to provide interim accommodation. So it might be a case of, again, just going down to the council with your child, with your suitcases, and just getting the council to actually, kind of actually act there and then. But as I say, be prepared for placements out of area, hospital accommodation, not nice places, basically. So yeah. Does that cover that one, do you reckon, guys?
I could make a contribution on this one. Hopefully that doorbell won't go off again. But I'm just playing devil's advocate here and sort of trying to stick up for the council in some situations. Because what we don't know, and I'm pretty sure this isn't going to be real, but we don't know how long this person's been living at his brother's home and why he's had to leave. Now, we're assuming that it's a temporary arrangement. His brother said, okay, you can stay for a bit, but you've got to go now, yeah? And the answer in that situation is the council are acting entirely unlawfully by saying, we're not going to accept you as homeless. And the answer to the question of can they deny accommodation is no, because the Section 188 duty should have kicked in. And really if you had unlimited access to lawyers, what should be happening now is a pre-action letter should be going off to the council saying this person's made an application, you're under a mandatory duty. They've now got until the 6th of January. If you haven't housed them by the 2nd of January, we'll be in court on the 3rd of January. I think, second, subject to bank holidays, but you know what I mean. And that way you get a court order on the 5th or 6th of January saying you've got to give them accommodation. But just to go back and play devil's advocate, let's suppose that he's been living at his brother's for the last 10 years and that him and his brother succeeded to the tenants. His brother succeeded to the parents' tenancy, and it's the family home. And it was always understood that he could live there indefinitely. But they've had a falling out, and he's asked him to leave. And legally, he can do that. Now, the council in that situation might be doing the right thing by saying, let's just see if we can intervene and mediate and keep things going. That's what's supposed to happen. I don't think it is what's happening. I think it's probably the first situation. But if it was the second one, that might be quite a useful thing, because it might be in everyone's interest for them to be able to get on again. The other thing is that the prevention duty is very useful in certain situations, particularly where somebody is facing eviction in possession proceedings, or they've had a notice of seeking possession from a landlord, say due to rent arrears. You can send people you can go to the council and say, help, I'm going to lose my home. Can you help prevent that? And they can do a lot. They can liaise with the landlord, they can look into legal remedies, and they can even make discretionary housing payments to clear large sums of rent arrears. So it does have its uses, but it's often misused. So that I had one today where somebody applied for accommodation because there was a rat infestation at their home, and they got a letter saying we've accepted a prevention duty. I mean, that's no use at all, because you're not saying help me keep my home, you're saying help, I need somewhere else because I've got rats. So that's my contribution, is that they definitely shouldn't do this where somebody's in priority need and mess about. But there could be situations where the prevention duty might be useful.
Yeah. So I mean, there's just further clarification there saying it's just a genuine family fallout. And yeah, there's multiple issues there, but yeah, I mean, it's in. I mean, I guess a kind of a third question might be worth going into is, let's say you've got someone who isn't in priority need. There's no reason to think they might be in priority needs. Then we get back to this same kind of thing of, well, you know, the council might be under prevention duty, might be under relief duty, but that doesn't actually involve housing the person come the 6th of January. So part of that prevention duty might be looking at other options around, I don't know, support accommodation. Let's say they're a single person, support accommodation or something like that. Hey, what, Mandy? Nice to have you here. That kind of ties in with the question that we got asked in the week, which you might as well answer now. That just going back to Isis' question. So we don't. I certainly don't have capacity to kind of like give specific email kind of advice. As I say, my full-time job is something completely different from this, and I just don't have the time of the day. So that's why we kind of run the live stream, is just to kind of provide some information as best we can. And partly as well, why just, you know, if you ask a question hypothetically about, you know, a hypothetical person, you'll get the same answer. So you can put stuff in there without, you know, disclosing private stuff, I guess. So I'm just checking. So someone just asked a follow-up question: can they decline giving you accommodation? I'm hoping we've covered that now. So if we go to the question that came in the week number 1, so this person, 31-year-old, currently living with the mother, trying to find his own place or her place. I assume male, but maybe not. So the adult child pays the mum rent. The mum has the tenancy. Let's just say it's a him, just to make it easier to explain. So he's 31, let's say, he might be a woman, but anyway. So he's trying to find his own place. He pays the mum the rent. It's the mum's tenancy, and the mum is unable to work herself. If she was to kick me out, would I be intentionally homeless? So I'm hoping we've kind of just covered that really just in what Will said. So yeah, basically, I mean, so Will, let's say this 31-year-old has been living with the mum since childhood. Does that change anything? So this is the family home, but it's still the mum's tenancy. So it doesn't, yeah, okay. So it's still the same situation. So the mum is the tenant. She is the one who can decide who does and doesn't stay with her. There might be some impacts for her if he was to move out or something, that, you know, potentially she would in effect be subject to the bedroom tax maybe. So and I appreciate, you know, if the son's earning and paying money or rent, whatever, then it's a bit different, but it's the same effect. So she would then potentially be in an under occupying 2-bed home, let's say, and she would only get, universal credit as if she was a single person. So she would probably get a very high banding on the housing register. Most housing registers I'm aware of will give you the highest band if you're under occupying, because the council wants you to move to a 1-bed, you free up a 2-bed. It's a good use of council resources. Does anyone add anything to that at all?
And I guess so it was around intentionality as well. I guess, if your mum was to write the letter kicking you out or the notice and what have you, and saying it's because of antisocial behaviour and illegal behaviour and potentially domestic abuse or all of those sorts of things, then potentially you could be intentionally homeless because it sounds like it's currently suitable to occupy. If she's just writing a notice saying can't cope with this anymore for my own sanity or whatever it might be, then I don't see how you would be intentionally homeless in that situation.
So I'm in my head. I'm trying to run through the kind of the 6-part intentional homelessness test that councils use in their decision, because I mean, I don't know. Would this be classed as settled accommodation? He's not a tenant. I don't know. I don't think I've worked in a situation like this before, actually. But I'm just thinking,
Would it be settled under a different definition because it's where they normally reside, even though it's not?
Yeah, I know what you mean. Yeah, no, I think I might need to go and have just read through that stuff. I don't know, just to kind of get my head around that. But yeah, no, so I get what you're saying. Yeah, I just don't know that I don't know.
Strictly speaking, your mother's home wouldn't be settled accommodation in the sense that it's not a tenancy. But there was a case some years ago, and it would take me a while to find it, but there was a young, I mean, he wasn't a child, but so he was a young man just out of his teens, but he was living with his mother and he wouldn't stop smoking weed. And she kept saying, stop doing it. And he wouldn't. So she kicked him out and they found him intentionally homeless. And I think everyone was a bit shocked because they said, well, he had no right to stay there. But the reasoning was, and I don't think it got appealed or anything, so it was only a county court decision. But the reasoning was, well, it was your home. You could have stayed there. You wouldn't have been homeless had you not deliberately ignored the rules. I was just looking. There's a case called there's somebody who got kicked out of accommodation, but that wasn't family accommodation for smoking. I was just searching for it. It was a long time ago, but in theory you could. But I don't think it depends on the reason why she kicked him out, why he'd be intentionally homeless. But I think a lot of councils would be wary of saying you're intentionally homeless for that. But then a lot of them wouldn't. They might have a go and see if you challenge it.
Yeah, I think so. I'm just looking at 9.7 of the Code of Guidance. So A, they deliberately do or fail to do anything in consequence of which they lose the accommodation. So Will's example, smoking weed. B, the accommodation is available for occupation. So that, in one sense, if the mum was happy and content with the person living there, then it is available. I don't know. I guess my question is it accommodation? I don't know. But yeah, okay, cool.
Yeah.
I mean, it's not obviously like annoying, being antisocial, whatever, is not recommended anyway. I might just need to have I'm interested by that question. I might have to just dig around a bit further, but I think
I'll try and find that case I was talking about.
Yeah, cool. Okay. So going back to the list of questions from the week. So we're kind of going back to this thread of like the duty to provide interim accommodation ending. So I think we have already covered this actually. So what appeals are available and who could help? So let's say you've been given a negative decision, for whatever reason, non-priority, intentional homelessness, no local connection, not homeless, or whatever it is. So you can use. Well, I'm trying to think. There are certain things you can't challenge through a review process, but all of those decisions can be challenged through the review process. There are certain things that can't. So, for example, and Will, you might correct me on this one, but suitability of temporary accommodation is not something. Suitability of interim accommodation, that initial accommodation that you're provided with, you can't do that. You can't deal with that through the review process. You've got to get a solicitor and go to court. I'm trying to think if there's anything else that can only be done with a solicitor, but certainly these kind of intentional homelessness decisions or whatever, or non-priority decisions, are all challengeable as a layperson. So my previous job at Just Us, that's what I did. And it's if you kind of do your homework or whatever, you can have a very high success rate with challenging those decisions, because in most decisions I ever saw, you could count to 10 before you see the fatal error in the council's argument. They just either miss stuff, or just kind of just perverse consideration of facts or whatever. So it wasn't actually that difficult generally. You just had to go through the process of putting a coherent letter together to challenge it within the 21-day period. But yeah, and a decision that doesn't tell you how to ask for review of it is going to be invalid, so that you can challenge that in itself. So it has to say at the end of it, it will just be a template. If you're not happy with this, you can write to joeblogs@council.gov.uk within 21 days, and that's how you do it. So but yeah, in terms of other people that can help you out, it's difficult for me to not sound too negative about this, but unfortunately a lot of charities will not challenge local authority decisions. They'll beat their chests and criticize Swell Bradman for having a go at saying that rough sleeping's a lifestyle choice, but they won't actually challenge a council when it comes to actually something that matters. So finding a solicitor service, someone like Shelter, that if they've got a legal centre near you, then that could be really good. Will's got a kind of a list of solicitors that get legal aid for housing cases, which I always put onto the comments that the kind of description of the videos once they go up, so you can check that out as well. But yeah, unfortunately, it's very much a postcode lottery as to whether you can find a service that will actually help you out in that situation. So sadly, that's partly why we do these videos. It might be down to you to make the argument. And I think, as Shannon said earlier, involving a counsellor will increase the chance of being treated fairly, because a lot of the reason this stuff happens is it's just behind closed doors and no one really gets held to account. Whereas if you're doing it with a counsellor involved, there is a higher chance that actually the council will give you fair consideration to your situation. So yeah.
Some CAB centres, like Citizens Advice Bureau, also have housing and homelessness specialists now. So again, I think it's a bit postcode lottery. Potentially, they're often separately funded, so they're more likely to challenge local authorities as well. We've met some good people through there, so it might be another opportunity.
Yeah, and there's so what again, like as a default position, if you can find a professional who is not funded by the housing part of the council, so it might be a social worker. Social workers don't tend to be so bothered about annoying housing officers, or it could be someone like an IDVA, independent domestic violence advisor, or someone like that who is not directly funded by the chief officer of housing. That's what a lot of professionals are scared of. They're scared they're going to lose their contract if they challenge a council, which is sad. But anyway, I guess it's the way it is. So that's kind of what I'd say really. And I don't, and I think you just got to be persistent. I've said before with the solicitors out there, they're busy and they're quite tough to get hold of sometimes. So you just have to be, persevere really. And I think that that kind of answers the fifth question as well. So if you've got any more questions to ask, guys, now is a very good time to do it, because I think we pretty much answered all the questions we were planning to. Will, so the question I've asked this before, Will, but it just it kind of ties in with what we've talked about this evening a little bit, and certainly one of the questions that were asked before you got here. So and I've asked this before, but no fault eviction, yeah. So let's say you're in rent arrears, the landlord's annoyed with you because you're in rent arrears, but they go down the Section 21 route, which is on paper no fault. Now, when you consider intentional homelessness in this situation, I keep referring to this 6-part test that councils tend to use. It comes out housing law, so it's sound. But one of the key things is, was it the deliberate act that led to you to lose the accommodation? Now, it might be you're in rent arrears, or it might be you're a difficult tenant for other reasons. But if that wasn't and the landlord might say, well, I was annoyed at you. But if that wasn't the reason for you losing the accommodation, is the Section 21 notice. So again, it seems like a really standard question that I should know the answer to. But what's your take on that one, Will?
Well, it's interesting you say, because I was having discussion, a big argument with somebody who's a lawyer for the YMCA today, and they're taking possession action against somebody using a notice to quit on a license, which is also no fault, as long as they've served the notice. And the person had £16,000 worth of rent arrears. Now, the court wasn't making any finding on the rent arrears. It was just going to say, yes, the license, notice to quit, you got to go. Now, for technical reasons, I did find a defence to that because they hadn't served the notice to quit properly. And the YMCA didn't want to have to discontinue their claim. So I was saying to them, well, look, we'll settle. You can have a possession order, but write a letter saying she had the rent arrears, excuse me, but it wasn't her fault. She didn't speak good English. She didn't understand the benefits. They wouldn't do that. And basically, I was trying to get them to say which the truth was. They hadn't provided her with any support, which they were supposed to do. And I said, why don't you just admit it? Then you can have possession and somebody gets told off a bit at the YMCA, but no, they wouldn't. But the other thing the other argument might be that the accommodation's unsuitable. Another one would be that I had a case once where I think they managed to produce a for sale notice that was outside the property and say, well, look, the landlord was selling it anyway, so it wasn't going to be available. And so as long as you can show that it's the real reason why, or a reason why you left the place was something that wasn't your fault, then you're not intentionally homeless, even if you've done 101 other things that would have led a landlord to get you out if they weren't going to get you out anyway. See what I mean?
Yeah. So you just mentioned there something which I was interested by. So you said a notice to quit for a license. What do you say about it? It's a no fault thing. So let's say you're in a YMCA and you punch the manager and you rightfully get evicted, get an eviction, a notice to quit or whatever. Are you saying that that's a no fault? What's the?
Well, I mean, you're right to question it because it could be that we could have said that this is an assured tenancy, it's dressed up as a license, but it was non-secure accommodation rented to people in a hostel type situation. And I think they might well have got away with saying it didn't fit all the criteria for a assured tenancy. And I should go away and double check that, but it looks like they're discontinuing the claim anyway. But I think, I mean, we've said before that if you're occupying a hotel, like a pure bed and breakfast, you don't need notice to quit. They can just come and kick you out and say, sorry, your stay is ending. Whereas if you've got a flat and it's let under a license, and forgive me, I think there are statutory exclusions that mean that license would be a valid license. They then have to serve a notice. And just for the record, where the service of the notice went wrong in this case was that they had a reception area at the YMCA, and they posted the notice to the person's address at the YMCA. And then what happens at the YMCA this is in Waltham Forest, is that if you get a letter, it comes into reception and they put it in a post box for you. And so effectively they were serving the notice on themselves, and nobody could know for sure whether the notice got put in the pigeonhole. And they wrote a letter saying somebody probably put it under a door if they didn't do that. So they didn't really know what had happened to it. So that was the defence, and a judge would probably buy that. But if they go for her again, because what they'll do is they'll get their act together, they'll then issue new proceedings, and then we'll be stuck. And then she'll go to the council and they'll say, oh, £16,000 rent arrears is intentionally homeless. So I can do a subject access request on the YMCA and I get all the records to show they never gave her any support. So we try and run the argument to say that it wasn't deliberate. But does that answer your question?
So just to follow up, I've got a question then. That wouldn't be deliberate, and so there's the issues with communication and language and support that the YMCA is not giving. Would she not have acted in good faith? So almost ignoring the deliberate act and just say, look, she acted in good faith. She joined supported accommodation thinking she'd get support with these issues. In the initial assessment, where you've assessed language, communication, and probably financial stuff, it's good faith to expect the support accommodation provider to support you. Would that be like I guess what makes sense to argue? Like what would you say?
Well, I would say that I mean, in this particular case, they helped her make the housing benefit claim in the first place, and the housing benefit was paid directly to them. And so if and the housing benefit stopped being paid, and it looked like they never told her, and so she didn't know about it until she got court papers saying you owe us 16,000. So you could say that she, in good faith, believed that everything was all right because they dealt with it on her behalf. You know, some sort of unsympathetic person might say, well, she should have been checking her rent account on a monthly basis and asking for a rent statement. But I think where you're in that situation where you think, well, they are supporting me, then I think that there's an argument to say that you shouldn't have to do that, or that the failure to do it wasn't deliberate and it was an error made in good faith. Yeah.
Surely they would have brought it up in a, you know, to get 16 grand's worth of rent arrears is not done overnight. Surely they got a key working session or something with them. I mean, it'd be interesting to see what you get from the subject access request. What was actually discussed in the key working sessions?
The interesting thing was, one of the reasons they wanted to discontinue the case was also because the solicitor just couldn't get the documents, because they were ordered to disclose their documents by 5 p.m. today, all of the documents from the file, and they just couldn't. She says, I just can't get them, so I'm probably just going to have to give up the case.
So, I mean, this is like, so it reminds me of a number of cases. One case I remember I might have talked about before, actually, where so she got evicted, and I don't know if she got evicted for arrears, but she had 3 grand worth of arrears or something. And that was the reason that she then couldn't get housed. So the housing, you know, the council was saying, well, you can't get on the housing register, or you can't get housed through the housing register because you've got these arrears. So I went back to the provider and said, right, subject to access request, let's see everything you've got, because we want to see what support you actually gave her. And they basically said, oh, actually, do you know what? Don't worry about it. You know, if you don't ask for the records, we won't, you know, kind of, we'll write a letter saying that the arrears have all been cleared. So it was an interesting way of kind of, because clearly they knew that the records were either inadequate, or they said something outrageous which was libelous or something which they could get sued for. So they didn't want us to see it, and it served the purpose in that situation, so they let it go. But yeah, I think so. We were asked about when so we do kind of like consultancy stuff, but we kind of do case management with some organisations. And one of the questions was around this was, you know, what advice did the person get when they moved in? You know, were they told about their benefit eligibility? Were they told about the impact of, you know, did a college course or something? And it messed everything up. But, you know, and I don't think there was any, you know, I don't think the hostel could actually show that they'd given any useful advice. Anyway, right. So I don't think we've got any more questions. I think that's all of us done this week. Any notices for anyone? Our next training is on the 2nd of February, which seems like miles away, but I'm sure it'll come around pretty quick.
Yeah.
It's only 6 weeks away, isn't it? It's sort of 6 or 7 weeks. But yeah, then we've got another one in February, and then yeah, can't remember what else. So also, yeah, a couple of things actually, just for the regulars. We're not quite sure how we're going to do this yet, but I just want to put this stuff out there. So Shannon and I are going to be running a group of some kind, whether it's a Facebook group or something, but it's going to be for people who really want to take on their local council, you know, not for their own case, but for general, you know, push for general improvement. So we've seen loads of good stuff happen in Bedford. There's other good stuff happening around the country, but we just want to kind of, yeah, get together with like-minded people and share knowledge, kind of share inspiration for different FOIs that are effective, that sort of thing. So keep an eye out. We're going to be announcing some stuff when we work out what exactly we're doing. And I had something else to say as well. I've now forgotten it. Oh yeah. So I think I haven't got very far with this yet, but I want to do another free event in like springtime. I want to get some like local politician type people involved in a kind of panel discussion and kind of talking about how we push for systemic improvements in the local council. So yeah, between councillors, you know, local reporters or whatever, I've got someone else in mind who would be very good at a lot of experience holding the government to account, but just kind of getting stuff in. So yeah, so keep an eye out for that as well. Cool. All right, guys.
Can I make one little announcement, or
yeah,
before
go for it.
Stop? I don't know if anybody's been following it, and I'd like to have had more time to follow it more closely. But there's a public inquiry going on at the moment into the post office and the way in which the post office persecuted a number of postmasters over the years because of problems with their computer system called Horizon, and the computer system wasn't adding up the accounts properly, so it looked like there was people were cooking the books. And rather than investigate the IT system, which everyone was complaining about, they actually prosecuted postmasters and sacked them and caused a hell of a lot of misery. And it's come to light, and they're now investigating it. But one of the really interesting things is it's demonstrating things that will be familiar to anybody that deals with homelessness or public authorities generally, is just how incompetent the people with power were. And for instance, last week they interviewed the guy who was the head of the criminal legal team, and he was shamefully bad. And he'd got no training and no background in criminal law. He was, but then this week they've had a guy giving evidence who was the chief investigator, and he's like a sort of witchfinder general, and he's going out there interviewing people. And when he interviews them and they tell him that the computer system's wrong, he ignores that and tells them things like, "You're up to no good." And then when he does his report, he doesn't mention that they'd raised the computer system. And he made comments like, well, one was using the F word, that there's going to be no effing chance of anybody fighting this. So if they put him in the witness box and say, well, what on earth was going on here? And he says, oh, I'm so embarrassed about what I did and I'm so sorry. But the interesting thing is that he has to admit that before he started this job, and remember, he's the chief investigator, he had no training. He describes it as very minimal training during his 12 years on the security team. And prior to joining the team, he had no experience of conducting criminal investigations or knowledge of criminal law. Now, this will remind you of your average, no disrespect to the good homeless officers out there, but there are loads of people in housing in the public sector who have no, very, very limited training and no real idea what they're doing. And they make up for that with a sort of vigor and aggression, which you should always remember when you're dealing with people, that you think you're dealing with people that really know what they're talking about, but you're probably talking to somebody that if they ever did get put in the inquiry witness box, which sadly they won't, they would be probably making confessions about, oh, I didn't know. And because we had this the other day, you get this in court so often, you get people who are investigated by what's called tenancy fraud officers, or local authorities have these sort of fraud investigations at people, and they get these titles, and you give somebody a title that's got security in the word, and they think they're sort of Sylvester Stallone or something, and they get really aggressive. And then when you actually examine it, they don't know what they're doing. So I would say this is very good reading, and it's all on YouTube. They're putting it's public, so you can watch these people being interviewed. But the moral of the story, I think, is that this is a microcosm of the wider issue of people with power who haven't been trained properly to use that power, and they make up for it. You probably know more psychological terms for this, Mike, but there's a sort of brutalization that if you don't know what you're doing, you sort of shoot first and ask questions later.
So on that note, so the head of the post office at the time, I'm trying to Google her name, but she's a vicar in our local C of E church, and kind of like local. I'm this is from memory, so I might be incorrect about a couple of things, but I'm sure I'm not going to get too much trouble with it. But kind of like a well-to-do person, and I think since the scandal broke, I think she's retained all of her, all kind of, because I think there's a local big kind of private school kind of organisation, Harper Trust. She was like on the board for them, and I think they were kind of like questions about whether they should keep her on there and stuff. But as far as I know, she's still doing what she did before, like no skin off her nose for all those people that were put in jail and had their lives ruined for it. Yeah,
and you've got the similar thing with people at the top of housing associations who are getting salaries which just outrageously high. I mean, you think, well, why on earth does somebody who runs a housing association get sort of 150,000 a year or something?
Oh, they're getting more, like they're getting like 300K. Like they're getting
Sorry,
they
I
get
mean,
more than the Prime Minister.
I
Yeah,
didn't
yeah, they
want
get.
to overdo it. Yeah, I mean, it's absolutely. It's like you find these people in academia that sort of admit, people that are head of some university. I mean, it's I suppose you got to be quite good to get that job, but it doesn't just. I mean, it adds to the sense that they're part of the great and the good, and they get away with this sort of thing. And it's probably, I mean, it's the fairly junior people. I felt a bit sorry for the criminal law team guy because he wasn't a sort of from the ruling class, as it were. And you get the feeling that maybe they'll throw a few junior people under the bus and the people with the big salaries. But that's another story. But it's worth checking out just to see how the institutions are more complicated and the people that are running them aren't trained properly. That's the takeaway point, I think. And with housing, you get decision letters that, as you say, you can spot the error within the sort of first 10 lines, and there's loads of just word salad and people trying to use the language of judges to make themselves sound like they know what they're talking about.
Yeah,
so
yeah,
that's
yeah. They'll quote a couple of sections they'd always go on about. It's like you remember like the old vulnerability case Pereira. So before Hotak, I mean it was a circular. It was a load of rubbish anyway. But if you actually read that Pereira case, it was quite interesting. It was far more useful than you might think. 'Cause it was about a guy who was I think he was rough sleeping. He had like substance use issue, that sort of thing. And there's a lot of stuff in there which actually would support the fact that someone in that situation could well be vulnerable. Like it wasn't.
But they
kind of
were. I mean, they lost Pereira. The council lost.
Yeah,
But it
I
was
didn't
just
realize
some
they
of the
lost it. But
takeaway points in there. And
yeah,
the reviewing officer in that case, who I won't name, but I knew him. I mean, I didn't know him personally, but I was worked against him. Was absolute clown. I shouldn't, because people can go and look him up and see. But I think that anybody that's ever dealt with him would say he's a good example of people that have just been over promoted and nobody's called him in. But I'm probably crossing a line here of being unprofessional. But
so it's all right. It's your opinion. It's all good, mate. Yeah, I think
yeah.
I think it's useful to be real about it. I think otherwise we kind of perpetuate this this kind of understanding that actually they know what they're talking about all the time. They don't. So yeah,
Nor do their lawyers either. But that's another story.
cool. All right, guys. Anything else we want to talk before we go? If not, we'll you back next week, guys. Yeah.
I'm away, but I might be able to join in from away, but I doubt it because it's getting quite close to Christmas, isn't it?
Yeah, so it'd be 21st. So yeah, and then I don't know what we're doing the week after. We'll figure it out. But yeah, I'll be here anyway. And it looks like Shannon will be as well. So if you can make it, that'd be great.
Fine.
Cool. All right, guys.